Hello, everyone, and welcome to this Legal 500 webinar in partnership with Pinheiro Neto, Brazilian Cybersecurity, Navigating Potential Risks and the Path to Compliance. My name is Joe Boswell. I'm Head of Research for the Legal 500 GC Powerlist, and I'll be introducing today's session, which will take a deep dive into some of the hot topics in the Brazilian cybersecurity world, as well as letting you know how to keep your company safe and compliant with the prevailing regulations. We have 4 topics for you today. In order, they are the Brazilian Cybersecurity Framework and Overlook, LGBT compliance, general cybersecurity measures, and Facebook Pay on WhatsApp, a case study. Firstly, I'd like to remind you that this session is interactive. So if you have questions at any point during the webinar, please type these into the Q&A function and our panel will do their best to answer them. We are very lucky to have a fantastic panel of cybersecurity experts with us to discuss the topic today, and I'll now ask them to introduce themselves. So Larissa, would you like to go first?
Hello, everyone. So thank you for the invite here for the webinar. It's really a pleasure to be here with Ciro from Pinheiro Neto and Ricardo from Facebook. We are colleagues and really good friends in this legal world. I'm partner of technology and data protection team at Pinheiro Neto. I have been here for 19 years. And thank you again. I think it will be a really good conversation today.
Ciro, would you like to go next?
Good morning from Brazil to all. My name is Ciro. I'm one of the partners of the technology practice in Pinheiro Neto, which includes data protection and cybersecurity measures. I've been working at Pinheiro Neto for a little over 20 years, most of that with issues that somehow involve personal data. I'm focused on litigation, not exclusively, but mostly. So I usually represent tech companies and other data processing agents in lawsuits and administrative proceedings, including those related to security incidents. It's a pleasure for me to talk to you about cybersecurity. Thank you.
And Ricardo?
Of course. Hi, good morning, everyone. Good afternoon, depending on where you are. It's a pleasure to be here. I'm Ricardo Maso. I am the head of privacy legal at Facebook for the Latin America and Canada region and country. It's a pleasure to be here. I know Ciro and Lari for many, many years. It's not a secret that either I came from Pinheiro Neto or that they are actually Facebook's. They actually provide advice to us on many, many topics. So I'm a fan of both Pinheiro Neto and Larissa and Ciro and other partners in particular. So it's a pleasure to be here and to have this conversation with all of you, Larissa, Ciro, and Joe.
Thanks very much, everyone. So I believe Ciro is going to start us off with an overview of the cybersecurity legal framework.
Right. In this first speech, we will give you an overview of the relevant Brazilian legislation. And the first thing I have to say about this is that Brazil doesn't have a single cybersecurity law or act. Instead, there is a number of relevant laws and regulations that deal with this issue. The main one is the General Data Protection Law, known as LGPD or GDPR, which is in effect for 1 year now. But there are also relevant legal provisions in our Internet Act, which we call Marco Civil, the civil rights framework for the Internet, in a decree that regulates this Internet Act, and also in the Consumer Protection Code, besides some rules applicable to specific types of businesses that we will talk about in a while. From the perspective of the Brazilian law, a security incident can be defined as an accidental or unlawful situation of destruction, loss, modification, dissemination, or even unauthorized access to personal data, which may cause some risk to the data subjects. The adoption of technical and administrative measures able to protect personal data from security incidents and to prevent damage to the data subjects are not only obligations imposed on data processing agents by the Brazilian law, but also principles adopted by the LGPD. The LGPD requires that these security measures are observed from the conception of products and services to their supply. And this is what we call privacy by design. And the systems used for processing of personal data also have to be structured in a way that they meet security standards and requirements. The LGPD does not specifically define which security measures have to be adopted by data processing agents, but it provides that the Brazilian Data Protection Authority may at some point establish minimum technical standards, take into account the nature of the data processed, the characteristics of the processing operations, and the current state of the art or the state of the technology. And by the way, the Brazilian legislation only exceptionally provides for security standards aimed at data protection. When it comes to internet service providers, for an example, there is a decree that requires the adoption of measures such as authentication mechanisms for access to data and techniques that guarantee the inviolability of data, such as encryption, but nothing that goes beyond that. Another relevant point is that the LGPD introduced in the Brazilian legal framework the mandatory communication of security incidents in a general way, in a broad way. The data controller is required to notify the data protection authority and the data subjects of the occurrence of security incident that may result in relevant risks or damages to the data subjects. And we will talk about that later. Larissa, would you please comment on the specific rules applicable to banks? Then I return to conclude talking about liability, please.
Oh, sure. So I think what is interesting for everyone to know is that although we have this general data protection law that requires, for instance, communication to data protection authority and other obligations there, we also have regulation specific to some sectors and industries in Brazil regarding data breach, security incident, cybersecurity. So one of them that is important to know is the cybersecurity regulation. It applies to the financial institutions in Brazil or payment institutions, the ones that are regulated by the central bank. And there are a couple of obligations there for instance, obligations to have some specific clauses in cloud service agreements, but also there are obligations to notify the Central Bank of Brazil in case of data breach. So before I give the word again to Ciro, so it's important to know that if there is an incident, a security incident, you have to know, in addition to the general data protection law, what to do, you have to know in your sector if there is specific regulation about data breach and security incident in order to provide notification to all the required authorities, not only the data protection authority in Brazil. So this is what is interesting to know about the Brazilian regulation.
Thank you, Larissa. Just to conclude, we expect that in the coming months, the Data Protection Authority starts to bring administrative proceedings to investigate and apply penalties on data processing agents for security incidents and other violations of the LGPD. And why? Because the provisions of the LGPD dealing with administrative penalties came into force on August 1st, 11 days ago. There are some aspects related to the administrative proceeding pending regulation, but the Data Protection Authority will probably start its sanctioning activity soon. The administrative penalties for a violation of the LGPD including for non-compliance with the obligation of security over data, over personal data, and lack of communication of security incidents, include fine of up to 2% of the revenue of the company or group in Brazil, limited to 50 million reais. And in addition to administrative penalties, violation of the LGPD may give rise to filing of lawsuits against the data processing agents, aiming at the adoption of corrective measures and the payment of compensation for property or moral damages caused to the data subjects. And we have already noticed an increase in the number of lawsuits filed against data processing agents based on the LGPD, including due to security incidents. These lawsuits can be filed individually by the data subjects or in the form of class actions filed by the public prosecutor office or private associations in charge of consumer protection, for instance. And finally, in the criminal sphere, Brazilian law defines as crimes some behaviors related to cybersecurity. These legal provisions were updated a month ago, by the way. For example, breaking into another one's computing device connected or not to the internet, seeking to obtain, modify, or destroy data or information without authorization. This is a crime under the Brazilian law, subject to 1 to 4 years of imprisonment and fine. But I have to say that this type of crime can only be performed and attributed to individuals who intentionally engage in the described behaviors. Legal entities cannot be held criminally liable in these cases in Brazil. And for a number of reasons, including lack of investments in technology for policy authorities, cases in which individuals who carry out cyber attacks are identified and punished are still scarce in Brazil. The focus in Brazil continues to be the service suppliers that act as data processing agents. Well, I think this is initial overview. And of course, if you have any question, I'll be available to answer. I think we should give the floor to Ricardo now. Thank you.
Yeah, so as we talked about the LGPD, the data protection law in Brazil, everyone knows that the companies have put a lot of efforts in order to implement their projects and their adequacy to the new law. We have been working a lot of that. The Brazilians in general have been working a lot of that on that. So, Ricardo, given your experience in implementing the LGPD in a huge tech company, could you share with us your experience? How was to implement this project, the challenge, what you have been working on with us?
Absolutely. As I was telling Joe, Larissa, and Ciro, I'm not very fond of long presentations. So I love the way, for instance, Ciro just did it like very quick, very brief, so we can actually talk about those topics. And I'm going to do the same. So I think the first, as Larissa and Ciro mentioned, is a challenge for every company to actually put in place practices and programs and processes that have in mind all this new legislation that is coming. And specifically on LGPD, I think the company has taken a position that it's very positive, because innovation and accountability shouldn't have to choose between one of them. Both of them are possible, and LGPD actually provides for that. So the company sees that and takes into consideration all those principles and all those rules in the programs it has implemented. And this is important. I wanted to touch two items very, very briefly. One is how to build a privacy program to meet not only LGPD needs, but global needs based on other laws as well, that sometimes they do talk with each other, sometimes they don't. And the second is what is most important for people, for users, for employees, for candidates. It's how do you put that in practice into day-to-day, in people's day-to-day, right? So, and on the first topic, of course, Facebook is a global company, so there is a global privacy program that starts at tone at the top. So with Mark, with Cheryl, with CPOs, with DPOs, and there is of course board oversight on that. There are trainings to every employee about that, because to meet expectations globally, we need that. And that's the same for LGPD. Of course, LGPD is a part of that global privacy program. And with respect to all the products, we mentioned Facebook, but Facebook, WhatsApp, Instagram, and others. And one of the first decisions is, okay, how to implement that, how to make sure this global privacy program also includes LGPD. And the first thing was to include references into the notices about LGPD. So that was made, that it was created channels for users to not use only users, but also candidates, employees, to exercise their data subject rights according to the local law. And also, of course, a key part for us was to consult with key academics and civil society on how to do that. And we have also been establishing good relationships with authorities, with the ANPD, with the Brazilian Data Protection Authority itself, on these channels, how they can be even improved, how they're actually being used by our users, and this is being provided to authorities when requested. And then the second issue, very briefly, is how to put that in practice, how to put that into people's day-to-day lives. There's one global process that is called privacy. That is a privacy risk assessment, which means, and it's called privacy review. This is public. There are very interesting posts from Michel Prodi, who is our chief privacy officer, and he describes how this works. So there's processes where even before product is designed, so privacy by design at its heart, as Ciro mentioned, policy, legal, product, privacy itself, engineers, so people, super cross-functional effort to analyze whether this new feature, this new product actually meets policy and legal obligations. And this comes from the very beginning. And again, LGPD is a part of that. LGPD is considered when a product is going to be launched in Brazil. So I'm going to stop there just because I want to make sure we talk about it. But I see this as a very important trend for the market. That is, despite the fact that many companies are global, the companies are taking into consideration LGPD because it's needed. Again, as I mentioned in the beginning, also because LGPD is a positive and is a business-friendly law, as you can say, because it takes into consideration not only the obligations that have to be considered, but also the innovation that must be respected, that must be prioritized for the companies. But it's important now, our approach is that now with ANPD and with other regulators, it's a moment to actually interact with them, understand what the concerns are, get feedback from our users. As Ciro mentioned, this law has been to effect for almost a year, more than a year already. So we're all reflecting on this law. Now it's time to continue to interact with civil society and others, but also interact with regulators and many regulators, specifically the Brazilian DPA. Brazilian DPA has been super collaborative and has been taking an approach that is positive to the market so far. I'm gonna stop that to make sure we're gonna talk a bit about it.
And Ricardo, you talked about the privacy by design, and as the head of privacy team, how is your team involved in new products, in new features? how do you interact with the engineers? How this happen in order to comply with privacy and data protection laws at Facebook?
No, that's perfect. So both the privacy, I joke about it, like this is the core of privacy by design, right? So when people are still thinking, they're still proposing a new feature in the process, many stakeholders have to get consulted about it. And that's when, depending on the product it's going to launch, depending on how big it's going to be, there are many, of course, criteria. Local council are also involved. So, and also policy teams locally are involved. So my team, the privacy policy team, the other teams are involved from the beginning to assess, okay, what is the privacy risk here involved? What are the principles we should consider? How, and then this is the moment to also adjust, right? Make adjustment to the product, to the feature, to adjust that. So again, this is a global process, but that takes into consideration and actually hears the concerns, the advice, the recommendations from the local teams.
Oh, that's fine. So we have heard about the Facebook experience in implementing LGPD. We have experienced other companies' implementation also. So what we can say here in the Brazilian experience is that when implementing LGPD in order to comply with cybersecurity measures in Brazil, what is important? I would say that we could split in four. The first one would be governance. So we should put governance, corporate governance for data protection in place. So who will be the DPO in Brazil? Who will be in charge of the privacy governance inside the company? Will the company have, for instance, a privacy committee that will be multidisciplinary in order to deal with that? So first one, governance, how the company will organize. So you can see, for instance, many financial companies in Brazil, they have started like a privacy team at Facebook and other tech companies. It was usual, but not in financial system companies. So they started like a huge privacy team with people from IT, people from legal, compliance. So this is the first. Second one, I would say that is educational measures. So workshop to the employees in order to share knowledge, to put everyone in the same page here. Training section could include also testing, sending fake emails to them in order to test the cybersecurity if they really understood how to react, for instance, in case of phishing, something like that. So the third would be more IT and security information measures. So for instance, to put in place the restriction to access to all the information. For instance, in one specific case we have worked on, we just realized that in HR department, all people would have access to the data there, so to the employees' data. Then we have to think about, should from the trainee to the director of the HR have access to all the data, or we should give strict access depending of the sensibility of the data. So this is important in terms of systems to put in place the security systems, the policies, the internal process for that. And fourth, then it's more legal, yeah? So then internal legal and compliance, I would say. So to put in place internal policies to the employees, to implement the privacy policies in Brazil in order to give third parties knowledge and transparency about what data is processed, for which purpose, what are their rights. So for instance, Ricardo talked about the access rights that data subjects have, and they can go to Facebook and request a report. So this is one of the rights that the companies have to implement. So then you have a bunch of legal requirements there and documents to put in place, the agreements, so data processing agreements. So this is the general experience in order to build a cybersecurity and data protection according to the law. And I know that Ciro was involved in many cases. So if you want to talk a little bit, Ciro, about the experience that you have here.
I totally agree with you, Larissa, and I will take this opportunity to answer one of the questions made in the Q&A about the hardest aspect of becoming compliant with the LGPD. Something that we notice when assisting a company to get compliance with the LGPD is the lack of a data protection culture in Brazil. Unlike in Europe, where data protection has been subject to general laws for decades, here in Brazil, the topic is recent for those who are not lawyers. Until recently, there was no much knowledge among many Brazilian companies about data protection. It's curious that some people are surprised when I say that recording of somebody's voice consists of personal data, because it's never been a concern here. So that's why it's important, as Larissa told, in the first stage of a compliance process, we usually hold meetings with the leaders of the relevant areas of our clients to share the main concepts, the rights and obligations provided by the LGPD to get everyone on the same page. Dissemination of this data protection culture among directors and employees is a very important step towards compliance with the LGPD. If Ricardo could add something about this topic, and then we can talk about other practical experiences.
Yeah, no, that's a good point. That's a great question. What is the hardest part? I think one of the important parts also, Ciro, to your point on the differences with the EU, is also understanding the differences from the EU. So many global companies that they have spent a lot of time, efforts, money in the past years to become compliant with GDPR in the EU and becoming compliant with other laws. Also understanding, and I think this is the moment we're now to understand, okay, what are the differences with the EU, right, between GDPR? And we internally, I think people talk about the deltas, the differences between, because the analogy between GDPR and LGPD, not all, as you both of you are certainly know, they are not all the time perfect, because the legislative process we went through actually changed many of the inspirations that the LGPD had. So many provisions are totally different. So I think one thing that is important for the companies is also to understand the differences, because sometimes LGPD is less stringent than GDPR, and sometimes it is more stringent. And sometimes we don't know, because there's still no signals or actually interpretations of the law, because it's too soon to say. So I think that's one of the on one hand is one of the most interesting parts, because you have to delve into those topics, understand what the differences are, but also one of the most challenging. And so that's why now the position of the DPA is super important, because there are some topics that we need, and they are doing that. Good regulation and orientation on those topics. So becoming always updated and close to those topics, I think that's challenging, but it's also the fun part of working on privacy issues, in my opinion.
And talking about challenge, there is a question here. What sort of companies are exempt from LGPD, from the data protection law? So this is interesting to talk, because in Brazil, the law does not make difference about the size of company, the volume of data that the company is processing in order to apply the law. So in general, the law will apply to every company or even natural person that for economic purpose process personal data. And personal data is data that identify or could identify a person in Brazil. And the law will apply the same. So for instance, there is a discussion in Brazil, because the law provides that the data protection officer should be appointed to by every company. So even if you talk about a company that there are only like 3 employees there, and this company process data, and usually all the companies will process personal data, because if you do not provide products or service to individuals as final clients, you probably will collect and process data from the employees. So it's personal data. So every company would have to appoint the data protection officer. So what is important to talk is that the exemptions are super small list, and more related to, for instance, in case you process data for national defense, national security, or for academic purpose, or for not commercial purpose. So it will apply to most of companies. So the Data Protection Authority in this dialogue, as Ricardo was telling here, propose a consultation to the public in general to ask about how to apply this law to small companies, startups in Brazil, or companies that are more related to innovation and disruption in Brazil. So all the companies could participate in this discussion to present comments to the authority. In particular, we have been involved on behalf of a fintech association. We had the opportunity to present to the authority comments how to soft the application of law to these startups in Brazil. And it was really great experience, because the Data Protection Authority, represented by many of the members, received the president, the executives of these associations of fintechs in order to discuss, do you know, these measures, what would be super strong, and they could really put in place all these obligations, but they want, for instance, they have the commitment to be in compliance with the law, but how we could soft some of the obligations to not put so burden on the companies that are just starting in Brazil. So this is one aspect that is interesting. Ciro, if you want to get other questions here.
Something that must be taken into account when implementing the compliance with the LGPD is the position of some of our administrative authorities, and also the ease of bringing lawsuits here in Brazil. We have already said that Data Protection Authority may soon start to bring proceedings, but there are other entities in Brazil, such as Senacom, a federal body in charge of consumer protection, which have been investigating and applying fines for some time in cases of security incidents that affect consumers' personal data, and not based on the LGPD, but on our consumer protection code, and in a very aggressive way. Senacom has already fined the company in $1 million for a security instance, for instance. And these actions will continue in parallel with the Data Protection Authority activities. And beside that, lawsuits resulting from security incidents are common in Brazil, both individual ones and class actions filed by the Public Prosecutor Office and Consumer Protection associations. Litigating in Brazil is very simple and cheap. It's cheap. The Public Prosecutor Office and these associations, for instance, by law, they cannot be ordered to pay court costs or attorney's fees, even if they lose the cases. And data subjects may file lawsuits without paying fees and without the need for an attorney when it comes to discussions linked to $4,000. It's even common for some of these associations to copy and paste in Brazil lawsuits filed in other countries in case of security incidents. For example, in the episode involving Cambridge Analytica, the first ruling on the merits rendered in the world was in a lawsuit filed in Brazil. And we have been involved in this type of lawsuits representing data processing agents for something like 6 or 7 years. And we have, I would say, a success rate above 95% in relation to compensation claims made against our clients. But we often see companies being fined in order to pay damage for security incidents in Brazil. This harsh environment makes it even more important that companies adopt security measures and get compliant with the Brazilian data protection legislation.
There is, when the law came to force, we have searched in there's a website in Brazil that you can claim, you can post their consumer claims. It's a non-governmental website. It's called Reclame Aqui. And we searched the claims in the first 2 weeks after the law has come to force. And we had about 200 claims regarding data protection in 2 weeks. And now I think 1 month ago, it was published in the press that we had more than 600 decisions on data protection in less than 1 year. So then you can see how litigator Brazilians are in regarding all the topics, including data protection. So there is one question, and Ricardo and Ciro, that it requests here on the litigation point of view, if the Brazilian legal community is still waiting for data protection aspects to be more stable. What do you believe that?
I think that's a good question. And now is the moment where, of course, the thresholds, the standards, the limits are being explored and tested. I think to your point, Ladi, and to Ciro's point, he said like that both of you have represented clients in this area, despite the fact that the LGPD, the Brazilian data protection law, does not exist. It goes like back for years, maybe a decade. Ciro, you were being nice, but 5 or 6 years. I know, we know you're old. I'm just kidding. I think it's a moment for that. I think, of course, claimants, respondents, they are always considering this law, and this is a good thing. So also providing information to judges, to all types of stakeholders about the law, what it is, what it is not. And it's also the moment, as both of you know, to also explain the basics to the society as a whole. We shouldn't see the legal community as the whole community. LGPD was created as a law to empower not only big company, but everyone. So it's a law that applies to everyone, to every people. So people have to understand that. So, and there are some dogmas that exist, some myths that people repeat that are being clarified in baby steps. So for instance, that consent is not the only legal basis, or it's not the predominant or a preferred legal basis. It's one of the 10 legal bases that LGPD provides for. And this is something that people are learning that with time and understanding what it means in their specific areas. So that's one thing. Another thing, as you mentioned, Ladi, we talked about a little bit about access rights. So what it means to have access rights, to what information, to which data a person has access. When I'll give Facebook's example. Facebook, I mentioned that there are specific channels created for people to ask questions directly to the data protection officer, to the DPO, asking questions about how data is treated, is processed. But there is also a tool where it's called download your information, and there's also access to information. We call it DYI, AYI. I know there's a lot of acronyms, but we're going to pronounce all the names for people to understand. And there's a way for users to actually have access to all the data that it is processed by the company, and it's used for the company to provide the services. And this is the moment where people actually try now understanding what it means. What it means if you're going to sign up for a different service, for a payment service, as you said, Ladi, what's the type of data that you're providing? What's the type of data that is being used? For what is being used? So I think it's a moment now where all the stakeholders, so not only judges, Cito mentioned some authorities, all of them are also learning how to do that with that in a favorable way for the country and for the data subjects. That's how I see it. So I don't see, I personally don't see litigation cases that we notice as a bad thing. I think it's a consequence of the moment we are, and we have to deal with them with, of course, with caution, but we have to learn from them and make sure everyone's understanding what's happening. You're right. I think there's sometimes some references that are too generic, and so only talk about consent or talk about having access to data or sharing data as a bad thing. Again, those are myths that with time need to be changed, and I think they are being changed slowly and with time.
Thanks a lot, everyone. I suppose now it would be a good time to move on to our next topic, which is general cybersecurity preparation, pretty much. So I think, Ricardo, you have obviously quite a lot of experiences with this sort of thing at Facebook. So yeah, if you could just tell us a little bit about some of the measures you've put in place.
Absolutely. As many, I know, and I'm sure Lari, Ciro, and many people here listening to us have plenty of experience in cybersecurity, so I won't go over the basics, but there are many practices to approach security. And one of the key ways to address that is adopt a multi-layered approach. There are many layers of measures that you have to take to try to prevent an incident, as Cito was describing. And at Facebook, and again, this is all public, some of the layers that exist are secure frameworks. So having frameworks in place, Ladi talked about governance a little bit. So companies, especially the big ones, need security experts writing libraries of code and new programming languages to prevent and remove bugs in general, because usually many incidents, they sometimes come from bugs and wrongdoers actually understanding those bugs and exploring them. So having frameworks and security experts looking at those codes, writing new programming languages, this is one of the key ways to do that. A second layer are automated testing tools. So analysis tools that can scan new and existing code for potential issues. So of course, we need human and we need automated ways to test that. Third layer is peer and design reviews. So at Facebook, there are human reviewers inspecting the code changes and providing feedback to engineers. So they are watchdogs of the engineers, and this is also needed. There are, of course, what we call red team exercises. So internal security experts to surface any points of vulnerability. So these red team exercises, they're also public. Most companies do have that, and that's also needed. And of course, this is something that works very well for many companies across the globe, the bug bounty program. So outside researchers, they are also incentivized to find and report those security flaws to the company. And this is one way, and this is how Facebook and other companies approach security, because this layered approach, of course, it reduces the numbers of bugs alive on the platform for all the products. I'm going to stop there. There's a lot I know it's hard to address security in like a 2 minutes point, but I just want to mention, because people sometimes they don't understand, because it's a super technical issue, right? So people think, oh, how this company did not prevent that issue, or how did this company is addressing that? So there are many layers and many teams working on that, and understanding the technical reasons behind each of those incidents that sometimes are not even considered incidents. I think Ciro explained that very well. There are some bugs that, depending on what they mean, they are not even incidents. They are not even breach. I think that's what we're just talking about, myths. There's also the myth of breaches. People always think that something is a breach, is a data breach, but sometimes it is not. Sometimes it's equally important, but it's not considered a breach for the purpose of the data protection laws. So this is also another myth that we have to digest. People have to understand what they mean, and of course, require from the companies accountability documents, and actually an accountability approach. And companies should be vocal about all the security measures that they take in place. And that's what I'm trying to do that in like 4 minutes.
And Ricardo, there is, I think one thing is interesting is there is no 100% bulletproof environment systems in the world, yeah? So what the companies should do is, like, you have talked a little bit about a bunch of security measures that Facebook has put in place. So in the end, what the companies should do in Brazil is to practice the best practice that you have for the IT security system, educational measures, as we have been talking. And there is one point that is important to mention, because it increased a lot. If in one hand, we have bugs, we have errors, on the other hand, we can have some concerns regarding like employees with intentionally or not intentionally doing like accessing and authorizing information, for instance. So what the companies should be prepared, companies should have educational measures for that, training sections for the employees, put restrictions and access tools to the employees. But there is one aspect that called my attention during the pandemic, that is how not all the companies in Brazil were prepared to response plans in case of cybersecurity attack, because it was not super common in the past to have, like, for instance, ransomware in Brazil. It increased a lot during the pandemic. And then we have experienced how to implement this in the companies, because, it's a nightmare when it happens. And usually you have to take decisions in 24 hours or less than 24 hours, in a couple of hours. So the companies should implement this response plan in Brazil. What it will, how they could build that internally. So first, I believe the companies should have the vendors in place. So should prepare itself for a case of cybersecurity. So for instance, the company should contact, before it happens, should contact the vendors, for instance, the forensic vendors, the ones that have experience to negotiate with hackers in Brazil, the ones that would be responsible, for instance, in case of public relations, to talk to the press, to write to the press, to give transparency to the press what is going on. So you cannot do that after you have a cyber attack, because you have just a couple of hours to deal with all, the systems, to put the system, to recover the system again. So what I really advise the companies is to talk to the vendors, to have the agreements with the vendors before everything could happen. We experienced a case here at the firm that after the cyber attack, the company needed at that moment to negotiate with the vendors. So we stayed during the night negotiating the agreements to provide the service. And then just on the next days, we were able, to put the agreements in place. So to have this contact with vendors, with legal team, with public relation, with forensic, and negotiation with hackers would be best. And then for sure, you should have experienced team, a tested team that knows the whole, what they have to do. So what are the authority at the company in order to take the decisions there? So who is going to be responsible for the security, how to protect the system, who will be, for instance, legal team, how they are going to address, do you know any claim that comes up, how the public relations team will deal with the press, with who they should talk about, and maybe to have some drafts already in place for that. So, and the last one is how the company will deal on the next day. So the company should know how to absorb the lessons in case of cyber attack. So in general, the Brazilian companies should put in place a response plan and test, this plan with methodology and train people in this plan in order to be prepared for cybersecurity. Here at the firm, we have experienced some cases. I think companies were super serious in dealing with that. They attend the claims of the clients. We didn't have any outcome that was bad in any of the case. Most of them were really prepared to deal with that. But a specific case, just to share the experience here, they needed to give transparency to the consumers because it was a data leakage about personal data of the consumers with important data there. So they had communicated the entire base. And it was interesting because they give so much transparency and support to the clients that they didn't have any, judicial or lawsuits against them because of that, because they were acting super serious. So my last recommendation here would be take it serious, respect the consumer, give transparency to the authority, to the consumer, put everything in place before, test everything before something happened or cybersecurity happened. I know, Ciro, that you have been dealing with some of them and you have the leading case. Can I say that is a leading case for communication of Data Protection Authority? If you could talk a little bit, how was that? How was to communicate with authority here in Brazil for data breach?
Okay, yeah, we act in a case in our office in which at the end of the process of adapting our client to the LGPD, the company suffered a ransomware attack. And
this is not Facebook, to be 100%
no,
clear.
It's
yeah,
not.
yeah, okay, yeah.
Of course, we analyzed the available information in couple of hours and concluded that it was necessary to communicate the incident to the Brazilian Data Protection Authority. That was probably the first incident report received by the Data Protection Authority. Of course, there was a lot of doubt and insecurity for us, but our decision was to follow exactly what was in the incident response plan that we had developed. And the result was the best possible one. No penalties, no administrative proceedings, no investigations, no lawsuits, because we did what we had to do to comply the law. So this is an important message. Communicating a data breach or a cybersecurity incident does not necessarily means suffer some penalty or pay compensation for damages. It's possible, and it's, I would say, probable that by communicating, the company complies in full the law, the Brazilian law, and this is really important, not only because of the need for compliance of the law, but for reputational reasons. Dealing in a right way with a cybersecurity incident may cause a very sensitive impact on the image of the company. That's why we are so dedicated to develop cyber response, data incident response plans, and follow that when something happens.
There is a question here, Ciro. I will give it to you. So cybersecurity attacks seems to be increasing massively in Brazil. What is your experience here?
I think so, but I have to be transparent. I don't have the numbers. I think so, but maybe not only because the cases are increasing, but because they are well known. You know, the press is putting a lot of focus on that, and information is available. So maybe they are increasing, but the news about that are still increasing. So it's not only something that just happened, but now we have a lot of focus on that.
And what I believe is that unlikely Facebook, that for instance, Facebook for sure had already a huge cybersecurity system in place. There are other companies in Brazil, they could be small, but deal with a huge amount of volume of data. Even when we talk about really small companies, and they didn't have, the investments ready in place in order to invest in systems, and they started to be attacked by hackers, and then they started for the first time to deal with this kind of issues. So now you can see many small companies hiring, like for instance, cloud service in order to protect the information there, because they were not really concerned about that in the past. And now we have all these obligations of the Brazilian data protection law, of the sectorial laws in the financial systems and other environments. So I believe because of that, we have this increase, let's say. And Ricardo, do you have comments here?
Yeah, no, I just want to touch one point that you and Ciro addressed, that is, more importantly, companies need to work on a framework, on an incident response framework. That is, for every issue that arises, that can be an incident or not, the company has to prepare a framework that addresses a threshold to analyze, okay, how I'm going to treat this. I'm going to consider this an incident? Yes, no. It's actually a line of mind map. Yes, no. Do I have to, as Ciro mentioned, do I have to notify that to ANPD or to other regulators depending on the area? Yes, no, depending on the threshold. Because I think being prepared for that situation, because let's face it, the most important part is the trust of your user. So you have, and for your user to trust, as Ciro mentioned, I think the example you mentioned, Ciro, is great, that a company did everything they should, and the results were positive because they analyzed all of that. They saw they had to actually gain the trust from the regulator and from the authority. So that's the right thing to do. So, and I think cybersecurity, like data protection, is a matter of people. People are using all of this. So you have to train people, you have to prepare people. That's, we forget about that. And one thing that I wanted to touch is, for the in-house counsel here listening to us, one thing that I love the most about my team, for instance, is that Larissa said that a couple of times. It is a super dynamic and what is the, I'm trying to find the word you use, Lari. It was like super different team. People were like, people are different.
Multidisciplinary, yeah.
Yeah, multidisciplinary team with different backgrounds. There are different people with different ideas, and I think that's great for people who want to work on cybersecurity, want to work on data protection, because having different views, it's core to any team. And it's the same here, because different people use technology, right? So actually everyone today uses technology. So people see the issues differently. So you need these different backgrounds and these different views. And this is also core here. So just want to highlight there. and appreciate my team, which is awesome.
So I believe we can go to the fourth part that is really related to your team. Yes, Joey?
Yeah, I think it's time. I suppose for the fourth section, we're going to use a case study to try and build as a starting point to talk about some wider issues. And that case study is Facebook Pay on WhatsApp, which is a extremely exciting initiative, which I gather Ricardo had quite a lot to do with. So again, I was wondering if you could provide a bit of information about that, and then the rest of the panel could jump in.
Absolutely. I think this is a good example, is a good case study, as you mentioned, Joe, because it touches some of the topics we touched here. So this is one product that, because it was being launched in Brazil, went through that process, that global process that I was talking, that we were addressing at the beginning of the conversation here, the global process, the global privacy process. It was privacy by design at its heart, because it was created considering the Brazilian law, as Larissa mentioned, considering also that there's a local entity in Brazil that was created to enable, and that is authorized, is licensed by the central bank, the Brazilian central bank. So there are also other regulations, and I'll let you speak about that, Lari, that are important here. So the first topic is, this is one example of product that at this very beginning, it was framed, it was designed, having in mind the legal obligations that are relevant here in Brazil. That's one point. I think the second point is, it is payments on WhatsApp. So people are still learning what it means, because it was just recently launched, but it means that you can basically send money to for now, to friends and family on WhatsApp. The Facebook entity here is an entity called Facebook Pagamentos, which has its own privacy policy. And that's the entity that is authorized and licensed by the central bank. The Facebook Inc. and the Facebook Pagamentos, they provide the service on WhatsApp. WhatsApp is the means for this service. And one important point is that these companies, this company, Facebook Pagamentos, is, I don't know what's the best translation, Larry, but it's a payment initiator, I would say, which is a super new figure created by the central bank that was that Facebook Pagamentos is using. So it's actually a way to send money on WhatsApp, but WhatsApp doesn't have access, of course, to much of the data. So one of the things that was one of the most important parts at the beginning was to clarify for users which data the users are providing, and which is the data that is being controlled by each of these entities. And this was, in my opinion, with a great advice from our outside counsel, very well reflected in the privacy policy. So it's clear, and creating a very clear privacy policy was of the utmost importance there. And in my opinion, it was successfully done. And the second part, which relates to cybersecurity, Joe, is actually to clarify. So one measure, I'll mention just one, that is a measure of cybersecurity, but it doesn't have to be super technical. It is, for instance, that if I register on Facebook Pay on WhatsApp on my phone, and I'm sending money to Ciro, to Lari, to you, actually to you now, because you're based outside of Brazil, I'm sorry for that. And for instance, someone has access to my account in another cell phone. One important measure, cybersecurity measure, is that this other person won't be able to have access to your Facebook Pay account, and won't have access to your your card data. This person in a new cell phone will have to create a whole new account and register the cards all over again in order to use the app. So it was a measure to prevent a situation where it's very unlikely that people actually get hacked on WhatsApp. What happened, unfortunately, is that sometimes people give the PIN number to others, or they are misled. But even if that happens, people are misled to and lose their accounts. And even in that case, I think one important clarification is that people won't be able to send money using your card or is your Facebook account. So that's one specific measure that was created on purpose. And it was an important cybersecurity measure to prevent any type of scams in this respect and to give the users the trust. And there's now a huge, there's a marketing materials right now clarifying that, explaining that to the users in a very dynamic and clear way. So users are comfortable when they actually open the WhatsApp, when that happens, that they're comfortable with the product and they're comfortable using that. I'll stop that. I hope this is clear. Ladi, I know this is super hard to explain, so if not clear, please clarify for us.
It was perfect. I think we all worked together on that. And one thing that was a challenge, but 100% well done, I will say, is how you deal with all the laws that would apply. Yeah, so we have the data protection law in Brazil, we have the banking secrets law, you have the regulations of the central bank in Brazil. So for everyone to be really comfortable, it's not only a tech product, a technology product, but it's also a product that is regulated by the central bank in Brazil. So Facebook had to comply with all the regulation that all other regulated companies by the central bank, they have to go through, for instance, the financial institutions, the payment institutions, and Facebook, as Ricardo said, is the first one in Brazil that is a payment initiator. So it was really leading case in Brazil. It's working well. It was really working with all the teams together, like compliance, policies, legal, engineering. I can tell that we have the meetings with the engineer team, Ricardo, in order to make sure all the privacy and data protection law will be in place. So this is really good experience to talk about how the company can deal with all these aspects in a multidisciplinary team to build a super secure and safe product and compliance with all the laws in all the sectors. So it was a study case for cyber and data protection law here in order to end my and I think Ricardo has a huge challenge, yes, to meet the engineer teams, to talk to the legal, it's not super easy.
But I think it's a good point, Ladi, but I think that's one of the most fun part of my job and my team's job. So I think that's why a lot of people want to work on tech issues or work as in-house. I receive many friends call me and say, hey, I want to do that. And they want to do it exactly for what you're saying. It's challenging because people with different backgrounds. But I think also is also, and I know both of you do that very well. I think there was a time where lawyers were seen as something apart, something totally separated from the business. And like today is totally clear that you have to be the person who knows how to actually allow for these conversations to happen, right? And to be a good mediator sometimes, and sometimes you have to be a speaker, right? So sometimes you have to vouch for one opinion or another. It doesn't mean you have to know all the about engineering or know anything technically, but you have to be some actually support the business. But I agree with you. Is one day there are days where I end my day saying, okay, I did that well, and sometimes not so well. So, but it's interesting, and that's why I think Facebook even stole some of lawyers from Pinheiro Neto to do that.
Should we take some questions then? So we've got a good question here, which is similar to another one we had earlier. I'll just read it out. It seems that at the end of all these processes regarding enforcing privacy laws and regulations, there are people. Although a data protection officer might have access to toolboxes and systems to help him, how much of a role does AI play in enforcing privacy? And then I suppose generally, how big is the human factor in cybersecurity, and how do you plan for that?
I can start. No, I think it's clear that AI has an important part there, but of course the DPO role goes beyond that. So there are many functions within it. In Brazil, there is still some room for interpretation on what it means to be a DPO, right? To be a encarregado, as we say in Portuguese. But regardless of that, I think there are some functions and some parts of the role of being a DPO there need human analysis, responding to requests for access, and we do have people working on that, supporting the DPO on that. And there are other parts that do need AI. I think we touched on the cybersecurity. I did touch that a little bit when I was explaining all the layers of security, and some of them, of course, I talk a little bit about automated means to prevent bugs and prevent vulnerabilities. But there's room for both. You just have to think cautiously about when to use when. But of course, there's room for AI. But when there's people, and you should have people dealing with people as well.
Got a question here. So Cisco, and I'm assuming this is to do with the report they've done recently, said that the majority of organizations are not prepared from a privacy and security perspective. You work in private practice and have a lot of different clients, Ciro and Larissa. Obviously, don't name any names, but just in general, how correct you feel that statement is?
I can take the beginning of this one. I mean, the huge companies, the big companies, they're ready for privacy and security. I would tell because of global practice that they have, as Ricardo talked about here about Facebook. So there are other companies, they have global standard. So they have to comply not only with the Brazilian data protection law, but also with the European law, with the laws of the other countries. So the bar is always really high to them in order to comply with all the different legislation in all the countries, and including like security systems. So I would say that they are ready for that. However, in Brazil, because of LGPD, the other companies, so the medium and the small companies in Brazil, starting also to be ready for that, because it's mandatory, the data protection law, so they have to be in compliance. So we have attained, for instance, even like startups at the firm. So the startups, as they sometimes deal with lots of personal data, for instance, case of credit. So they are now ready to be in compliance with the laws. They have already, many of them have already put in place, like a data protection governance. They have appointed a DPO. They have gone through, for instance, a data mapping. All the mandatory process in the law, they have already complied with. And you see, is startups, sometimes it's company that they have like 20 employees, and they have made some of the employees to be focused on that. But for sure, when we talk about small companies, think about stores in a shopping mall. They have just like 1, 2, 3 employees. So how they could deal with all these systems, all these obligations. This is why we really are waiting for the Data Protection Authority in Brazil to put in place some regulation to soft the obligations to them. It will be fair, let's say.
I completely agree with Larissa. I would say that most of our clients are ready for deal with the LGPD, but we have to understand that there are many other companies, small companies in Brazil. Of course, the small bakery my neighborhood are not ready to comply with the LGPD, and no one expects that. This is a ongoing process. I believe in some months or maybe in some years, we will have the companies in a better position. It's not something that you do from a day to another. It's an ongoing process. And I can make a parallel with the Brazilian Consumer Protection Code. When it came into force, it was very hard for companies in Brazil to comply with all the requirements. And nowadays we see that most of the companies can comply with most of the legal obligations. So that's why it's so important that we have a responsive authority. I believe that the role to be played by the authority will help companies to comply with the law. So of course, the situation nowadays is not the best one. We have a long way ahead, but I believe that companies will comply it in the coming months.
Cool. Great. Thanks a lot. I think that would be a nice place to wrap things up, guys, unless you had any other comments you wanted to add. But other than that, thanks again to all of our panelists for making this such a great webinar. Thanks also to our audience. Great questions, as always. I suppose the only thing to say is this has been a Legal 500 webinar sponsored by Pinheiro Neto. Thanks for everyone watching. Thanks to our panelists. See you all again soon and have a great rest of the day. Thanks a lot, guys.